We're speaking today with Eric Orts, a professor of legal studies and business ethics at Wharton, about his new book released in September here, titled Business Persons, A Legal Theory of the Firm. Thanks for joining us today, Eric.
Oh, you're welcome. I'm happy to be here.
A book covers a lot of ground, but I think today I'd like to focus on a couple of specific ideas in the book that were very interesting. One has to do with executive compensation, and the second has to do with the Citizens United Supreme Court case, which gave corporations the right to spend, I think, unlimited amounts on political groups and campaigns and candidates and that kind of thing. So based on the Citizens United decision, corporations are people too, right? Or are they?
Well, that's one of the main questions that I try to answer in the book, or at least elucidate. So the title of the book is called Business Persons, and what I mainly argue in much of the book is that corporations are persons, but that doesn't mean that they're people, and therefore, as the majority of the Supreme Court said, they have all of the rights, apparently, that people do.
Persons, not people. Interesting
distinction. Now it's interesting because actually people are persons in legal terms as well, and so we don't treat all people equally either. So infants are treated differently than adults. Aliens are treated differently than citizens. Slavery was a big issue for many years until rights were accorded to every person without any discrimination. So the idea of legal persons is quite a deep and difficult idea in the law in general. And what I try to talk about in the book is how businesses are persons, and really it wouldn't make any sense to think of them not as persons, or it would cause a radical revolution in how we act every day. So businesses own property, and they have rights to protect that property. Businesses are constructed and have legal rights of standing to protect those who are working in the business. So in that sense, businesses can be said to represent people, and people represent businesses.
But there's some things they can't do, right? They can't vote.
That's correct.
They can't go to jail.
There are some rights that clearly corporations do not have. It's not possible to put a business in jail, although it's possible to put people who are acting on behalf of businesses in jail. And there's a debate in the law about whether companies and other businesses should be criminally culpable. So some countries say it doesn't make any sense to say a company could be committing a crime. In the United States, that's different, and we currently have the SAC capital case, or the SAC company case, where that issue is being raised. So there are many different kinds of questions, and with respect to the Citizens United case, what I argue is that the court really, both sides of the opinion, both sides of the Supreme Court decision in Citizens United, I think, do not go deeply enough into the question of what does it mean to say that corporations are persons. And then once you start thinking about that, you might come to a better answer than either yes, they do have all these rights, or no, they don't have any rights.
So you disagree with the Supreme Court's decision.
Actually, I disagree with both the majority decision and the minority decision. So I'm sure it'll be a popular argument.
Let's start with the majority decision. They went too far. They gave away too many rights to.
I think the majority decision basically doesn't go into the question very carefully by saying, well, look, here are all these cases in which we have found corporations to have rights as persons. Therefore, they have rights for political speech. Now, it might make sense to give corporations rights for political speech in some context, but on the other hand, it might not. And so there are questions that are raised in the dissent, for example, that for many years there have been a question of if companies get too involved in politics, isn't there going to be a corruption problem where companies are only going to be supporting issues and candidates that are going to benefit them? Is the public interest really going to result in the best laws that way?
Is that
because
there
be some restrictions?
Is that because they would have an outsized amount of money to
Well, it's partly,
push those
that's another
issues?
argument. Another argument is that, and Justice Stevens in dissent raises this argument as well, is that there'll be too much influence if you allow companies into politics. The other argument, though, is a corruption argument, and that is it's clear that there are some limitations. So almost everyone agrees that bribery should not be allowed. You shouldn't be allowed to go to Congress and say, hey, I'll give you this much money if you vote in this way. That's clearly illegal. What's not so clear is what about these grayer areas where you have campaign financing and other and campaigns in general where you have the various organizations active in trying to inform public opinion, and what is the legitimate role of business in that process? My feeling is that there's probably a gray area where sometimes you want to have the public informed about issues that business is going to be closest at knowing about, and they should have a right to be talking about those issues. On the other hand, when it's sliding over into a question of potential corruption or potential distortion of the process, then I think Justice Stevens has a good argument. Now, on the other hand, I think the dissent goes too far by saying corporations are not people, therefore they're not persons, therefore we can do any kind of regulation whatsoever. If we follow that argument to its logical extreme, we'd have a lot of problems also. For example, can a company protect its own property? A lot of property in the United States and the Western world in general is in corporations, is technically and legally owned by those corporations. So to say that they would have no constitutional right of property or to protect their property would seem to override all the individual people's interests in that property and
Do you
firms.
think that's what the dissent was suggesting, or you're simply saying that's the logical
Well, I think
conclusion?
that's the logic of it. The dissent doesn't really parse where you're going to draw a line here, and I think that was a weakness of the dissenting opinion. So you're going to see this issue. I think it's not going to be disappearing after Citizens United. You're going to continue to have this kind of question raised.
So there's a lot of, you could imagine a lot of different kinds of cases that would be in the middle. Is there any sort of practical way to think about this? What makes sense, what doesn't? Just as an average person looking at what seems fair.
Well,
both
one
sides.
suggestion I make in the book is that maybe both sides can come to what President Gutman has called a spirit of compromise. And her recent book, she talks about there are cases, people remember cases where Democrats and Republicans actually agree on things and pass legislation.
President Gutman being
President
of the
Amy
University
Gutman
of
of the University,
Pennsylvania.
right. But I
Pennsylvania.
argue that one example here should be, although it isn't presently, that everyone should, I think, agree that if companies are contributing money to political campaigns or making political advertisements, it should be disclosed that that's happening. Now, some people there are people who argue against that, but I think that would be at least one step in the right direction of having some transparency in the process. And there are privately, there are some groups that are arguing for political accountability. There are shareholder groups who are trying to get companies to do this. Many companies do this on their own. And many companies actually have decided just to opt out of this whole process. So just because the Supreme Court says companies have a right to be involved in politics, a lot of companies don't decide not to get involved in politics because you might just get everyone angry at you, and that's no way to sell your products.
Requiring companies to disclose how much they're giving and who they're giving it to seems like a reasonable thing, but that's actually not required under the current law. What are the arguments against that?
Well, I think someone who takes a very strong view that corporations have political rights and they're the same as any individual adult might say, well, individual adults don't have to disclose this sort of thing, so you can vote and it's secret, for example. But I think that the reasons that we allow that sort of non-disclosure, for example, secret balloting, don't apply when you are talking about problems of potential corruption or distortion of the political process. I think at the end of the day, most political scientists or others who look at what democracy is about would say that mainly it's voters that should decide, and that means individual human beings. No one is arguing that corporations have a right to vote, for example. Stevens makes a lot of that in his dissent. So clearly we have to some kinds of restrictions are obviously appropriate, and this seems to me to be one that might start to put some balance into the system.